Thank you very much. Somebody slipped you that anecdote about how I got my first summer job. The truth was, I collected, and I don't know who that was, as a matter of fact, but I now know people in the national security establishment who can track that individual down. The truth of the matter was I had large numbers of dimes in my pocket, and I went into the basement of the Russell Senate Office Building and started calling offices, and finally one administrative assistant to now long-gone Senator Gaylord Nelson said, well, we could discuss something. When can you get here? And I said, well, when would you like to speak to me? And he said, well, if you get here sometime today. So I got the elevator and went upstairs and knocked on his door. And he was so astonished by my ability, if you will, to transport myself like that, sort of like Bill Shatner, that he said, oh, I'll take him, fine. In any event, I want to thank the Dean and Chris Wimbush and Andrea Parisi and others for inviting me here today, and also for a splendid set of arrangements that has made this a very, very easy trip, and I appreciate that very much. I also was going to open by talking about the way in which my arrival at the campus sort of inspired me with nostalgia, but I don't recognize any piece of this property here. I recall that I went to Clark Hall. Last year it was near the lawn, and that was sort of a perfectly serviceable one-building exercise in legal education. And then something here was opened, a building, but it was nothing like what I have to say looks like a massive legal metropolis. Chris took me on a tour, and I still couldn't probably find my way around. It was very impressive. I do remember, however, from my student days here, a number of experiences that were vivid and instructive, and in particular, the opening speech. This is what I thought of most immediately when I was invited here, the opening speech that was delivered to the incoming law students by Dean Hardy Dillard. And it was a remarkably pithy and illuminating speech about what lawyers needed to do to serve their clients well and to be persuasive, and I learned an enormous amount from it. I did not learn all from it that I thought I did, because not about a year later, I failed to advance beyond the first round in the moot court competition. And I failed because Dean Dillard drew a sharp distinction between being clever and being persuasive. And while I might have been either, this stony-faced panel of enrobed law students did not find me persuasive. So I do remember some things about the law school. Now for the years since. As the dean stated in his introduction, I have for most of my career specialized in political law, so maybe a moment of definition would be helpful here. Political law meaning the rules and regulations, the statutes and the regulatory edicts by which political activity in the United States is conducted, by which elections are influenced, and by which laws, one way or the other, in both debate and enactment, are also moved. This would include state and federal campaign finance laws. It would include the body of laws that are designed to guide office holders in staying faithful to the public trust and elevating that over narrow private interests. It would include what we have heard a great deal about since 2000, and I'll return to this shortly, the processes by which we guarantee eligible voters access to the polls, and the rules by which we expect to have their ballots accurately counted. And I was fortunate to have embarked on this career in the 1970s at the outset of what are called mistakenly, but I'll use the term anyway, the Watergate reforms. But before I discuss that, let me just say a word about what I'm going to be attempting to say about that reform period and what followed, and I also want to issue a disclaimer. The disclaimer is that I'm not here as a partisan. I'm speaking purely for myself and as a graduate of this student and someone who is specialized in this area of law. If I seem, as I will be, critical of much current anti-reform activity, and I'll explain to you what I mean by that, I will also tell you that I've tried to be relatively objective about these matters over time, and I have been critical over the years about pieces of the reform program that's most prominently associated with my party. But what I want to discuss now is a development in the years following the reforms, the Watergate reforms, which I will describe sort of in their growth very, very briefly, the development of what I would say is a doctrinaire anti-reform movement that gives me great pause and that I think should be of general concern. So let me make my case. For roughly 3 decades, as I said, beginning in the early 1930s, one political reform followed after another, and it's worthwhile remembering how rapid and remarkable this development was. First came the campaign finance laws, the enactment of the Federal Election Campaign Act of 1971, and then amendments in 1974 and 1976. These were laws that refreshed and sought to toughen existing but much ignored limits on contributions, source restrictions on the expenditure for political purposes of monies spent by corporations and unions, disclosure requirements, that is to say, compelled reporting of money spent to influence the outcome of federal elections. Not too long afterwards came a whole new slew of ethics reforms by which the United States Congress, speaking now of this at the federal level primarily, the United States Congress sought to impose rules upon its members, rules of ethical conduct meant to guide them in attending to the public over the private interest. There were criminal law enforcement developments of note as well. Public corruption cases jumped up dramatically in number. Fresh theories of prosecution, the honest services theory of prosecution, prosecutions under racketeering statutes expanded over this period of time. Lobbying law reform also came about over this period of time, compelled disclosure of spending not to influence elections, but actually to influence the proposal or the lobbying of particular pieces of legislation in the United States Congress. And the 2000 election, if you want to look at it this way, capped all of this off by waking up the country to the degraded and unreliable condition of election administration and equipment. In 2002, the Congress passed the Help America Vote Act, which initiated the gradual retirement of the notorious punch card machines with their hanging and dimpled chads, and it also established the Election Assistance Administration that was designed to provide support for improved electoral administration. Now, I'm not going to say that all of this occurred to sustained applause from all quarters. There were critics, there was dissent. Some of it was partisan, some of it was ideological, some of it was grounded in public policy and constitutional objections. In some cases, those objections, those complaints all ran somewhat indistinctly together. So there were voices of caution and voices of concern, but at the same time, a general sense that we had entered into a reform period that was exceptional for its rapid pace, its ambition, its exceptional coverage. Now, shortly after the turn of this century, that is to say from 2000 on, we found the reform program, I think it's fair to say, showing first signs of strain and then plain and persistent indications of severe stress. And a major marker was Mccain-Feingold that the dean referred to. It was a reform measure passed in 2002 primarily, though not exclusively, to shore up cracks that had shown in the foundation of the Watergate reforms and that threatened, quite frankly, to cause them to collapse altogether. What this was principally about, to remind you, was soft money, unregulated corporate, individual, and union money that was beginning to flow around the contribution limits and source restrictions and to some extent the disclosure requirements I just mentioned a few minutes ago. The significance of Mccain-Feingold, in my view, was double-sided. It was enacted in 2002, became effective in 2003 for the 2004 election. Its double-sided significance was as follows. It was a reform of a reform, that is to say, in stemming the flow of soft money, but it also gradually ushered in a period where unmistakably anything approaching agreement on reform began to come apart, evidenced in some measure by the bitter partisan battle over the passage of the law and then the systematic challenges brought against the law in the Supreme Court and in other ways, much of it to prove quite successful. In the less than 10 years from the passage of Mccain-Feingold, the Supreme Court now has heard and sustained challenges to major provisions of this reform measure. Excised from the law, maybe a little bit of an exaggeration, significantly altered and narrowed in the law, was a provision that was designed to ban what was called sham issue advertising, sometimes travels mistakenly under the name of negative campaign advertising, paid for by corporations and unions out of general treasury sources. The charge then was, and the evidence suggested, that some corporate and union spenders sought to get around the fundamental Watergate restrictions by paying for ads that were not explicit about their electioneering intent, but were unmistakable in their purpose. So most of you will recognize ads of this kind are the ones that say various unpleasant things about Bob Bauer, and then they close by saying, call Bob Bauer, tell him to stop being sort of a bottom-feeding slime ball. Most people thought, broadcast immediately before an election, that would be unfavorable to Bob Bauer's election prospects. And the Supreme Court significantly narrowed this provision, which applied without regard to words of express advocacy to advertisements like this run immediately before an election that referred to a particular candidate, but was a time-bound provision meant to ward off these circumventions of the Watergate reforms. After that, the Supreme Court dealt with another provision of McCain-Feingold, which was meant to assist candidates who were competing with self-financed millionaire opponents. And in Davis versus Federal Election Commission, the Supreme Court struck down the so-called Millionaires Amendment. But the court, seemingly provoked, did not stop there. Presented with one other issue under McCain-Feingold, the court took the occasion, in the now famous case of Citizens United, to abandon a very significant precedent it had established some period before, and to allow corporations for the first time clearly, no need to get into an argument about how unprecedented this was, because one does hear that argument from time to time, but I think it was a radical departure from understandings of the law, and it allowed corporations to spend independently, and unions, out of their general treasury funds for express election year advertising. That is to say, independently meaning not coordinated with a candidate. It was to be their own speech. And that was what the court found to be the overriding consideration in the case, the free speech rights of corporations and unions using their own money, provided candidates were not involved in assisting in any way in fashioning the content or directing the placement of the ad or in other ways. And so very rapidly the impression, I think, fairly develops through McCain-Feingold that not only McCain-Feingold, but some of the other underpinnings of reform that had been in effect for many decades were beginning to come apart. Now, it is not only within the familiar realm of campaign finance regulations this challenge to reform emerged. Consider voting rights, which I mentioned earlier, to be secured through election reform, which at one point was a cause célèbre in the wake of the 2000 election and the Supreme Court's decision in Bush versus Gore. In roughly 10 years, this post-2000 reform movement was roughly in tatters. And the debate on this issue has taken a sharply different course than one might have thought immediately after 2000. On the federal level, the Help America Vote Act, though it was quite a modest reform in the first place, has had a seriously hard time of it. One scholar, sympathetic to its goals, admits that it has, quote, not been viewed as a success. One critic on Capitol Hill, not sympathetic to its goals, has declared it to be, quote, the perfect example of what's wrong with Washington, unquote. Now the case for improved access to the polls competes with the case for more limited access. Voting rights claims vie for attention with voting fraud claims. Around the country, some of you may have read this recently in a front-page piece in the New York Times, state legislatures have enacted or are considering passing laws to limit access to the polls in a variety of ways, through voter identification requirements, photo ID requirements, restrictions on third-party voter registration drives, limitations on early voting, and in other ways. Using those two examples, and I could use many others but would be significantly challenging the time available here, it is fair to say that reform has either come under direct attack or it's been redefined, as in the case of voting rights, to mean something quite different than what we'd imagined it to be. And I'm not speaking here of any particular reform that's sort of dissected for its failings, it's held up to close scrutiny and found deficient or ineffective in one way or the other. That's what every enactment like this kind ultimately must undergo. And I've certainly done a fair amount of that in my own writing and speaking over the years. But I think under systematic assault and examination are some core premises here, core reform premises in a variety of areas, strikingly across the board. So if for decades when we thought of reform organizations, we thought of advocacy organizations like the League of Women Voters or Common Cause, we now see springing up across the country anti-reform organizations advocating against these reforms, attempting to show that government in the enactment or implementation of these reforms is either infringing intolerably on free speech rights or doing the bidding of partisans or helping office holders to retrench themselves in office. As good an example as any, and more surprising than most, is the reevaluation that we now have in progress about the values of disclosure of political spending. Reporting, disclosure, just putting information out. Now, once disclosure was a blessed refuge from disagreement, disputants could repair to some corner and all concur that Justice Brandeis was right, that sunlight was the best disinfectant and electricity the most efficient policeman. But as, among others, Norm Ornstein has noted, disclosure has now come under attack. It's raising eyebrows, in fact, if not objections among reform critics who question the longstanding assumptions about its value. One senior legislator that he cites condemns proposals for enhanced disclosure as, quote, a cynical effort to muzzle critics of this administration and its allies in Congress, unquote. And a major paper commenting on a reform proposal built around disclosure says this, quote, disclosure sounds good, but liberals have begun to wield it as a weapon to vilify business donors. Now, we've seen this point of view, this anti-disclosure view, or this highly skeptical view of disclosure, advanced in the regulatory process through proposals for less rather than more disclosure by corporate spenders in the wake of Citizens United. And Congress, also in the aftermath of that statute, was unable to pass the so-called Disclose Act, which was meant to respond to this new era of unlimited corporate and union spending with disclosure requirements, but unable to pass it with a bipartisan majority. When I say pass it with a bipartisan majority, pass it with any meaningful share of votes on the Republican side of the aisle. The debate was just marked from beginning to end with suspicion about the purposes of disclosure and what lay behind the statute that had been introduced after Citizens United to provide for it. Now, my point here is not, I have to emphasize this, and it's never been, that all disclosure proposals, like any other reform proposal, are sound or well-constructed or beyond debate, or that we shouldn't carefully consider the costs and benefits of disclosure laws and proposals. We should. But what we are seeing here, I think, is something more than that. We are seeing a challenge to basic assumptions about the requirements for democratic self-government. And in this case, I think it's telling that disclosure, which once united very much the participants in this debate who disagreed about virtually everything else, has been swept up in this reconsideration. The criticism of disclosure is revealing in another respect, which is we see throughout this debate a really renewed, emphatic stress on motivation, the motivation behind reforms. Without a doubt, partisans have, throughout history, either developed or lobbied reform proposals that work to their advantage. No question about it. On the other hand, what we now hear is an insistence that this is invariably and hopelessly the case, that reform, including disclosure reform, is a plot, it's a trick, it's a ploy designed to confer partisan advantage or to inflict injury on political competitors. We could picture this, and I'll say more about this in a moment, as another cost of political polarization. But whatever the cause is, this politics of anti-reform has exacted an enormous toll on the reform debate and the reform enterprise overall. One place where this shows specifically, and I think this is as clear an indication of what we're looking at as anything else, are the travails currently visible in the enforcement of reforms. Take the Federal Election Commission, which administers the campaign finance reforms. It has suffered through, I'd have to say, escalating internal partisan conflict, and on major issues, it typically produces deadlock. The Office of Congressional Ethics, some of you may be familiar with, was established only a few years ago to provide an independent mechanism for people outside the House of Representatives, that is to say people who are not members of Congress, to refer allegations of ethical misconduct to the Office of Congressional Ethics for further review and referral to the House Ethics Committee, which is the ultimate disciplinary body managed by members to enforce the House rules. The Office of Congressional Ethics, still barely in its infancy, clashes periodically and fairly sharply with the House Ethics Committee. The House Ethics Committee, in turn, is driven by its own partisan conflicts and recently appointed a special counsel to investigate itself. In the recent administration, claims of partisan manipulation, that is to say the administration before this one, but to some degree in this one as well, claims of partisan manipulation have been lodged against the enforcement of the voting rights laws, including irregularities alleged in the pursuit of voting fraud cases. And the criminal justice system, with its public corruption pursuits, has not been free of these problems, as evidenced by some difficulties that you have read about in high-profile public corruption prosecutions. So all of this obviously gives reform something of a bad name. As I have noted, perhaps it's in part a reflection of the broad polarization in the political dialogue and in the electorate that is much commented upon. Anti-government politics plays a role here as well, as skeptics contend that government is asserting controls beyond its proper boundaries, either because that's what it is wont to do or to assist those who hold office to hold on to office. And if Americans believe their politics is suspect, and often enough even corrupt, then reforms enacted that ultimately do not appear to be producing the better government they look for are likely to be dismissed as useless, with the costs outweighing the benefits. I should also note as a lawyer that the sheer complexity of the reform enterprise as it has developed over time has presented some significant difficulties for mobilizing constituencies for reform. Incomprehensibility begets suspicion. The more complicated reforms get, the campaign finance laws being a good example, the harder it is to hold people's attention, much less their support. And frustration always attends the need to hire lawyers and accountants as a precondition for conducting political activity. Nothing serves to chill a room more, I want to warn you in advance of your careers here, than somebody announcing that something is a Employ the Lawyers Act. There are many things that reform is lauded for, but employing lawyers like me, not one of them. All of these explanations for what has happened to the Watergate reforms, what lies behind the development of this somewhat doctrinaire opposition, all of these explanations could be reasonable. In my view, none of them are justifications for abandoning altogether the rules that are required to guard against corrupt practice, the appearance of corrupt practice, protection of the franchise, and promotion of confidence in the integrity of government. What is troubling and distinguishes, I think, this period from others is this inflexible and dogmatic character of the rejection of core premises, far different from a complaint or an objection to any particular enactment that goes to its effectiveness or to the way in which it bumps up against constitutional limits. And where this program takes hold, the consequences have to be taken seriously, particularly, as in this case, where the anti-reform program has attracted active support from a dedicated majority on the United States Supreme Court. So let me turn for a second to one telling example of what has recently emerged in the courts as sort of an outlook that I think bears upon the discussion we're having here. The Supreme Court this last term decided a case involving the Arizona Public Financing Statute. It was Arizona Free Enterprise Club versus Bennett. The state of Arizona enacted a ballot initiative which had the effect of providing public financing and in particular, and this was what was controversial, a matching fund component for participating candidates. Designed really to recruit candidates into the system, the matching fund component was monies made available up to a limit for participating candidates receiving public financing who were likely to face an opponent who spent well beyond the public financing limits, or independent expenditure groups who, of course, operate completely outside that system. And the court concluded that this matching fund component, this money provided, again, up to a limit, to address those competitive pressures was a burden on speech and could not be sustained. And the court struck this down. And for those of you who haven't had a chance to read it, there's a very spirited dissent by Justice Kagan, the first time that she's written at length on campaign finance matters. Now, the court seemed particularly troubled, and this is what I think is significant, or one of the significant features of the case, by the stress on the plight of independent expenditure groups. Chief Justice Roberts criticized the dissenting justices for ignoring the plight of those groups, a plight that he declared could be accepted on faith, just in the logic of matter, just on the logic of the matter, without any indication, any empirical proof that their speech was really being adversely affected. These groups, the Chief Justice said, were entitled to what he called autonomy in the choice of the message. And they should not have to face the possibility that because their spending would trigger matching fund payments to a candidate, they might have to either change their message or choose not to speak at all. There was really no meaningful evidence in the record that independent expenditure groups faced that choice, felt they were facing that choice, or would in fact disappear from the landscape because they were intimidated by the Arizona Public Financing Statute. And so these groups, protected in their speech, able to spend unlimited amounts of money to support the candidates that they wish to support. Nowadays, groups, by the way, that can accept unlimited corporate, union, and individual money were the focal point of the decision. It was their plight, their autonomy, that received the court's most active consideration in the analysis. This, I think it is fair to say, is a victory of ideological resistance to what I think Justice Kagan correctly characterized to be modest reform. The blocking of a reform initiative that involves no limits on the spender, solely in the protection of their so-called autonomy, says much about this highly skeptical reform outlook. After all, this same court, the same Supreme Court, has helped to usher in the period of what are now known as super PACs, collecting unlimited donations from all sources, and it seems that the solicitude for the autonomy of these organizations, as privileged as they are under the Constitution and under the law, is sorely misplaced. Many years ago, Judge John T. Noonan Jr., who taught at the University of California and then has served for many years on the Ninth Circuit Court of Appeals, wrote a remarkable book on the history of bribery. And he asked then whether or not there was a risk that the bribery ethic would be privatized, a privatization that would be justified on a number of theories, that everybody does it, that bribery laws were unenforceable, that its adverse effects were overstated, or that the bribe could not really be distinguished from an ordinary gift or a campaign donation. And this is a fair framing of one of the questions that one can ask about this current surge in anti-reform politics. The question of whether it leads inevitably to privatization of the political process, except in the administration of voting rights, where participation turns on access and not on wealth. And yet the law somehow tolerates burdens there while eliminating them for super PACs. Now, some will say, and I think with some justification, that the pendulum in American political history swings way back and forth. Periodically, a scandal erupts and a new reform period is ushered in, and that this will happen again, just in the nature of politics and by public demand. But law made in the middle of political tumult is law made hurriedly and often is headed eventually for backlash. And it seems odd, too, that our commitment to reform as a country has to depend on political calamity. We ought to be able to think the issues through, to weigh benefits and burdens, take into account the changed nature of contemporary political practice, and address fundamental expectations that Americans have about the integrity of their political process. As we contemplate and participate in the debate now underway about severe inequalities in the distribution of wealth in this country, an increasingly privatized political process can only exacerbate the risk of corrupt political practice and the collapse of public confidence in government. And on this last point, the appearance of corruption, I want to add a note. Some find the appearance of corruption an objective too slight and the likelihood of improving appearances too low to justify crafting reforms on that ground alone. And I once thought this, and I no longer do. For its part, the Supreme Court takes appearances quite seriously. In narrowing the basis of campaign finance regulation, the court has stayed still, even under the current court, with the goal of protecting against corruption or its appearance. And in fact, in another context where I think it has acted mistakenly, it is public confidence that the court has referred to in upholding voter identification requirements for voters. The court believing that if the public has a fear of fraud, it can deter eligible voters who have the appropriate identification from voting at all. They won't go to the polls because they'll be afraid that the ballots that they cast are in some way rendered less meaningful or nullified by illegal voting. But this was argued by the court as an appearance issue, that was a troubling appearance that justified these photo identification requirements. So the court seems to stand firm that we do worry about how people judge their political process and the credibility with which they view their government. We should work with the conceptual equipment that the court has supplied, especially in view of the chronic, deep distrust that Americans have of government and politics, which flares up and fluctuates over time, but it's never far away from us. In 1960, the groundbreaking political scientist Alexander Hurd wrote this, quote, "When reflecting on them separately, Americans revere both their economic wealth and their political democracy. In contrast, the two juxtaposed in government inspire something less than reverence. These are sentiments at the heart of American political culture. Public confidence is not a trifle, and it is not to be trifled with, except at a great cost to political participation and the quality of self-government." Now, because I fiddle endlessly with speech text, I added the following on the whole subject of corruption because my wife read the speech draft and said, this part isn't clear. And if there's one thing I've learned, that's advice I listen to very closely. There's no doubting for a minute the difficulties of establishing a conception of corruption or appearance that is firm enough, does enough work to avoid that indeterminate quality that chills the blood of free speech advocates. And I consider myself a free speech advocate, and I understand this concern. The concept of corruption or its appearance cannot be so weakly defined and elastic in application that it justifies any manner of regulation. But it is not a conception without weight. And in the anti-reform movements of the time, it is given the shortest shrift, boiled down to almost nothing. Consider this exchange, which I find striking, between the Chief Justice of the United States and the Attorney General of the state of Vermont, who is defending a campaign finance enactment that involved limits on expenditures and very strict limits on contributions. The case was called Randall versus Sorrell. The opinion of the court was authored by Justice Breyer. The Vermont law did not fare well before the court, and I'm not even suggesting here for a moment that I think the case was wrongly decided. I'm actually confident that in some respects the case was rightly decided. However, in the exchange between the Attorney General and the Chief Justice of the United States Supreme Court, the Chief wants the Attorney General to say one way or the other, is Vermont a corrupt or a clean state? And he presses the point insistently. And the Attorney General argues that the citizens of his state, by wide margins, are troubled, that they fear, and some lawmakers have conceded, that money moves policy. And he seems to argue in a contention that the Chief Justice brushes aside that public dissatisfaction and office holder unease reported at these high levels have to count for something. It cannot be a choice, he seems to think, and the Chief Justice does not, between clean or corrupt, either the one or the other. States struggle, as does the federal government, with keeping the public trust. And the absence of a simple answer does not mean we don't have a problem. So this is the choice that I think is presented by the anti-reform politics that I've been describing here. We either have a system that is increasingly privatized in many areas and defended energetically by able advocates seeking to discredit the very conception of reform, or we have reform laws that can be developed and ultimately managed with bipartisan and public support and a reasonable degree of effectiveness. Realism about objectives is critical here. We have to be modest in the choice of means, both in the identification of the objective and the identification of the path by which we can achieve that objective. Reform history, of which we have a good bit and which is a core part of our political history, has a lot to teach us about the approaches that will work and the ones that we'd have to be very careful to modify and to consider, especially in light of experience and contemporary political practice. This work is hard. Old conceptions, like corruption and the appearance of corruption, have to be rethought from the bottom up. Disappointments are inevitable. But, and again, I'd like to quote from Professor Hurd, these are his words, "A cherished democratic privilege is the right to pour social energy into the endless struggle for government reform. That Americans are continuously revising the substance and procedures of their government accounts significantly for the resilience and stamina of the republic." I want to reread that second sentence. That Americans are continually revising the substance and procedures of their government accounts significantly for the resilience and stamina of the republic. I think that's correct. I think reform debate is a core part of the political debate in this country. I think it is clear, it has been true for as long as I've been in political life, that Americans demand a degree of accountability from their government that only many of these reform proposals are calculated to really answer. This isn't to say, and I consider myself as sort of committed on free speech issues as anyone in my party, this is not to say that we don't worry about partisan influence over the design of reforms, the carelessness with which reforms might be assembled without regard to constitutional limitations. We have to worry about those things. We have to worry about the sort of political uses of reform. We have to continually evaluate reform in light of contemporary practice. We have to judge the effectiveness of reform rigorously. But we cannot make this out to be just one more brickbat that is thrown back and forth between one side or the other. We cannot turn reform into something that is almost by definition disqualified, because it is the government ultimately that enacts reforms, sometimes under public pressure, sometimes under the guidance of its wiser leaders. We can't have it so sucked into the polarization of the debate, which includes, of course, this line of aggressive anti-government rhetoric, that all reform proposals are discredited almost at the outset, virtually in the early utterances of any suggestion that a reform is failing and new reforms have to be considered, revised, and put in their place. And so I want to conclude here by stressing, again, not as a partisan, but as somebody who spent almost 30 years on this subject, that while once I was worried we were being careless in the pursuit of reform, now I'm very troubled that there is an extremism in the opposition to reform, a sort of recklessness and a doctrinary quality that is going to go a long, long way if it is taken to its logical conclusion into further undermining the very sort of fragile and critical trust that people have in their government and in the quality and effectiveness of self-government. And with that, I'm happy to take any questions that you have.